morning, everybody. Welcome back to the Law and Crime Network. I'm Jesse Weber, and as you know, we cover some of the most interesting live trials and legal stories in the country today, and I'm very happy that you're joining us because we have a lot to talk about and a lot to cover. So let's get started. Let's get right into it. We are going to continue our live coverage of the Wallace Bradsher case out of North Carolina. Now, this case is probably one of my favorites. How often do you get a district attorney who's in the hot seat, a district attorney who's the defendant, and a district attorney who is defending himself? That man right there, he is on trial. It is alleged that he, along with another district attorney named Craig Blitzer, entered into a scam to hire each other's wives for their own offices, pay them for no-show jobs. Basically, they paid them, but they didn't do any work. Now, this is a serious case about elected officials who are being accused of being very, very, very greedy. Let's talk about this for a second. So this man, Wallace Bradsher, is accused of hiring Cindy Blitzer, Craig Blitzer's wife, paying her $48,000, and she didn't do any work. In fact, she was going to nursing school and was at home for most of this. Now, this is what he's alleged to have done. But it should be noted that Mr. Blitzer, his co-conspirator, already pled guilty. Cindy Blitzer will not be tried in connection with this situation. But Craig Blitzer, for the past 2 days or so, has been on the stand. And he's not only been testifying for the prosecution, things have been getting very interesting because he is being cross-examined by his co-conspirator, Wallace Bradsher. How often do you get a defendant who's representing himself getting to ask questions to his co-conspirator? It's pretty amazing to watch. We are going to replay some of his testimony today, and we are waiting for the live feed. There's a lot to talk about in that case, and you never like to see attorneys in hot water. I expect better. But we'll talk more about it in a minute. The other case that we want to talk about, in case you missed it, we have an update. It is the Yesenia Sesmas case. We have a verdict in that case. We'll talk about it in a minute. But before we get into any of our live trials or discussion of any of those cases, we have our top crime stories of the day. Take a look. Thanks, Anthony. Those are some great stories. You can learn more about them on lawandcrime.com. And I got to tell you, the Grand Theft Auto one is interesting. I don't think he's going to regenerate in a hospital or outside of a police station. He loses all of his weapons and gets free to go. Don't think that's going to happen for him. It's a much different situation. But before we get into our main cases of the day, I want to bring on my very special guest, former New York City Special Victims Prosecutor and currently the Managing Director at Kroll, the investigation firm, Dan Schorr. Dan, it's great to see you.
It's great to see you. Good morning, Jesse.
You haven't been involved in Grand Theft Auto in real life.
My attorney asked me not to talk about that, so I'd ask if you
that's fair.
That's
a good answer.
I
now,
appreciate that.
Here's what we're going to do. We are going to tell our viewers, we are going to replay, in case you haven't seen it, the verdict in the Yesenia Sesmas case. So this woman was an illegal Mexican national who was on trial for the murder of Laura Abarca Nogueta, a young mother who gave birth to a beautiful baby girl named Baby Sophia. 6 days after Sophia was born, Laura was shot dead in the head. And the question became, who did this? Who did it? Well, investigators had very strong evidence that Yesenia Sesmas, who knew Laura for about 8 years, they worked together, was the one who did this. And why would she do this? Well, according to the prosecution, Yesenia was pregnant. She was pregnant just like Laura, except she suffered a miscarriage. And people didn't know that she suffered a miscarriage. She didn't tell anybody. In fact, she still had her baby bump. So according to the state, Yesenia went over to her house, went over to Laura's house, shot her in the head in cold blood, stole that baby, brought it back to Texas, and told everybody that this was her baby, that she gave birth in Wichita, Kansas. Now, what we've seen in this case has been some really, really disturbing details, and I keep saying it, the saddest part about it is that baby Sophia is going to grow up and not know her mother, and having to explain to her what ultimately happened is a really, really tough situation. But the question is, was Yesenia Sesmas the person that committed this crime? First, she told investigators that it wasn't her, that she hired another individual, a Hispanic male with tattoos, as the person who might have done this. She wanted the baby taken because, according to her, she had this agreement with Laura to give up the baby. That if Laura gave birth to a baby girl, she was going to give the baby to Yesenia. Laura backs out of it. She hires this other person, this mysterious man, to take this baby from her. That story didn't fly. Then Yesenia tells detectives, okay, I went into her apartment, I had a gun, I threatened her, but the gun accidentally went off. I didn't intend to kill her, that was never my intention, but that's what happened. Now, I want to make sure, do we have the verdict? Do we have the verdict, guys? Okay. Ladies and gentlemen, for anybody who missed it, here is the verdict in the Yesenia Sesmas case. There you have it. Guilty across the board. And that woman, Yesenia Sesmas, who you just were watching, she'll be sentenced in July, and she could face life in prison. It was interesting to watch the video. She's literally shaking. And the reason that is interesting to note is because earlier on in the case, she suffered from chest pains and anxiety and had to be hospitalized during the course of this case. So you can see how unbelievably anxious she was when that verdict was ultimately rendered. Let's bring back in, and let me give you a better title. Now, I'm remiss to call you by your new title, Law and Crime Trial Analyst Dan Schorr. Dan, it's great to have you here, and I want to talk more about the Yesenia Sesmas case. I can't say I'm surprised. I'm not sure if you're surprised by the verdict, but really, she didn't cover this up in any which way. She can't be that surprised that she was found guilty.
No, the verdict was really clear here. She not only admitted to shooting the victim, she then was found with the baby. So there's really not much of an excuse, or obviously she can't raise a self-defense claim. She can't say it was somebody else. She said the shooting wasn't intentional, that she held the gun to the victim's head and that it went off, but she didn't intend to shoot her. That's not really credible, especially when she took the baby and ran with it and then pretended it was her baby. And then when you see her shaking like that, it's really interesting, because I've seen so many verdicts where someone, putting aside what she did, she just was told that she's probably going to spend the rest of her life in prison because the sentence is up to life. And different defendants take that different ways. Some are very stoic, some are prepared for it, and some have reactions like that where they start shaking. For her, that's a horrible moment. Now, a lot of people would argue it's a deserved moment because she killed a young mother, and now this girl's going to grow up without her mother.
She was found with baby Sophia and the murder weapon. How do you mount a defense against these charges? I mean, the defense kind of said, well, we're going to tell you the definitions of intentional, we're going to tell you the definitions of reckless. Don't automatically assume that this was an intentional killing. But really, if you're sitting in the jury, common sense, you're going to bring a gun into an apartment, point it at someone, and it just accidentally goes off?
And she's not denying, right, she's not denying that she shot her. She has the baby.
She first tried to.
Right, but at trial, there's no denying that she shot her. And,
right.
And she does ultimately make that statement to law enforcement that's used here, that she did it accidentally. So there really is no factual defense here. She can't really, like as I said before, what's she going to say? Self-defense, someone else did it. The defense did not call any witnesses. They did the generic reasonable doubt argument, or find a lower charge conviction type of argument, but there was no way to say, look, she just didn't do it. Now, maybe they tried to negotiate a plea bargain and were unsuccessful, and the prosecution had no reason to plea bargain because the case was so strong. But once they're going to trial, it's hard to see how the defense could have done anything that would have led to an acquittal here.
Should be noted that there's no insanity defense in this state either. I think it's one of 4 states. Kansas doesn't have the insanity defense, so that was not an option for her to say that she suffered from some sort of mental disease or defect that would prohibit her from conforming her actions to the law. She couldn't prevent herself from doing this. So she really had limited options, and now she suffered with the reality of what's awaiting her. And there you have it. You're looking at a feed of her. That was her. Yesenia Sesmas. We'll cover probably her sentencing later on in July, but again, we do expect life in prison. Let's switch gears, though, and focus on our main live trial. Now, this one, I can't talk enough about this case. It's out of North Carolina. You have a district attorney. Usually on the network, we cover district attorneys who are standing up there, speaking in front of the jury, questioning witnesses. This guy is the defendant. Right there, Wallace Bradsher is a district attorney who I talked about earlier in the program, is on trial for basically stealing taxpayer money and conspiracy and aiding and abetting. So he is alleged to have operated this illegal scheme with another district attorney named Craig Blitzer. And let's just take a step back. There was a ruling in North Carolina that said these district attorneys couldn't employ their own wives in their offices, even though that's what they were doing for a period of time. So they said, they met up at a pizza shop, allegedly, and came up with this scheme. Well, why don't we hire each other's wives? A little bit of a wife swap. And the question became, okay, well, that's fine. The ethics office said that's legal. The problem is that these wives really didn't do any work. And what we're talking about is Cindy Blitzer, who is Craig Blitzer's wife that worked in Wallace Bradsher's office. She was paid $48,000 for work she didn't do. And she was actually in nursing school at the time and was still getting paid. Now, it's according to Blitzer in the state, Bradsher asked Blitzer and his wife to lie for him, and that he was the one that was really to blame for this whole situation. Now, who is the most important witness we could have in this case? Craig Blitzer himself, the man, the co-conspirator who pled guilty to this, and he doesn't know what his sentence will ultimately be, but he is testifying against his co-conspirator, Wallace Bradsher. Let's play you some of his direct testimony from the other day, and we'll talk about how this whole event transpired. How do you have two elected officials who are being accused of doing such an illegal scheme? Let's learn a little bit more about it. There's Craig Blitzer testifying against the defendant, Wallace Bradsher, his co-conspirator. Dan Schorr, question for you. If this is actually all true, did they really think they were going to get away with it? How do you get away? They work in an office where everybody sees what's going on.
Yeah, I was Inspector General in Yonkers, New York, and I investigate a lot of fraud and corruption. And no-show jobs, patronage, that's commonplace, unfortunately, throughout the country. What's shocking here is two things. First of all, these are district attorneys doing it. These aren't just elected officials, which unfortunately we see arrested all the time for corruption and getting people jobs and all this other fraud. Here, they're district attorneys. They're elected to enforce the law to protect the public. And two of them, not just one of them, two of them got together and allegedly arranged this. And second of all, once the wives have these jobs, they have jobs that probably an average person wouldn't get. You had to be married to a district attorney to get them here, and they didn't even show up, allegedly. So it's astounding that once you're getting a patronage job, you then take the extra step of not even showing up. And of course, people are going to notice that. What people often rely on in government when they have these types of situations is that people are afraid to report it, because who wants to challenge a sitting district attorney and accuse his wife of not showing up for work? But here there was a whistleblower who brought it forward, and here we are today with two district attorneys allegedly conspiring together for this fraud.
What they've been accused of is so egregious. Mr. Blitzer, who you just heard, it said that he had his employees take his wife's online classes for him. I mean, you can say if you're in one of their offices, I don't know what's really going on, maybe I'm looking at it the wrong way, but if you are sitting there and taking your wife's online classes, I still don't get it. I don't get how you think you can be above this. So what is Bradsher, the defendant, how is he defending himself, in your opinion? What is he saying?
Well, and this is interesting. He's cross-examining Blitzer, who's his kind of co-conspirator.
And you never see that.
Not only you see someone cross-examining their co-conspirator, you're seeing a former DA cross-examining his former DA co-conspirator. It's shocking, and he's trying to knock down some of the allegations that Blitzer's making, that maybe we didn't agree to this, as you say, and this didn't happen, as you said. But, you know, people unfortunately get away with this kind of conduct. You mentioned that one of the DAs made his employees take his wife's class, but that didn't come out until these allegations of a no-show job came out. So they would have gotten away with that, presumably. So unfortunately, this kind of thing happens in government when there's not transparency, when there's not independent oversight. And usually the DA is supposed to be the independent oversight over the rest of the government looking at fraud and corruption. So when the DA himself is doing something like this, allegedly, who's looking at him?
Right. Well, the state is, and the jurors are, and all of us are. But we want to know a little bit more about the relationship between Blitzer and Bradsher and the conversations they had. So this is, again, is a continuation of when Craig Blitzer, the co-conspirator in this case, who already pled guilty, is now testifying against Mr. Bradsher, explained the conversations that he had with him about this whole wife swap, no-show job situation. Take a look. That is the testimony of Craig Blitzer, the co-conspirator in the Wallace Bradsher case out of North Carolina. Got to tell you, I'm here with Dan Schorr, law and crime trial analyst, and also the managing director at Kroll, the investigation firm. You investigate a lot of different matters. These guys are smart guys. They're elected officials. They're accused of doing a workaround. They knew what the law was. The law was that they couldn't hire their own wives to work in their offices. So they did this swap, right? The whole thing with this case for me is, you know the law. You know what you're supposed to do and what you're not supposed to do. How does that change when you're two elected lawyers, two elected district attorneys? That idea of, oh, well, we didn't know what was going on. I just followed Bradsher's lead. And Blitzer said, well, Bradsher accused Blitzer of following his attorney's lead. They don't know what the law is?
Right. Ignorance of the law is no excuse for anybody. But then you add that you're a lawyer, and then you add that you're an elected official, and then you add that you're the district attorney in charge of enforcing the laws. And it's really no excuse. And there's a few really interesting things here. So he says at first he thought he could hire his wife. He found out he couldn't. They arranged this wife-swapping agreement where they hired each other's wives. Why didn't they get their wives' jobs somewhere else? Certainly, they're both connected people. They're elected district attorneys in the legal community. They must know a lot of people. They can't get their wives or help them, or their wives can't get on their own some other job. They have to get these jobs in each other's offices. And then, finally, why don't they show up to work? Because the allegation is they're not actually showing up and doing these jobs. If they had just done the swap and they worked for each other and the wives showed up and diligently did their jobs, they might have been accused of wrongdoing and the wives might have had to leave. You never would have had a criminal trial here.
Let's say they just showed up but didn't do any work. Couldn't you argue, well, it was a slow day. It was a slow period of work. We didn't have a lot going in. I didn't have a lot for her to do. Isn't that, they could have even done that.
Right. It would have been harder to prove this case because how can you prove what they were doing all day at their desk? Right. So that's true. All they had to do is some semblance of appearing to be in their jobs, and still there might have been an allegation, hey, you can't hire each other's wives. That's wrong. You never would have seen a criminal trial. You never would have seen two district attorneys accused of misconduct in a criminal way and facing prison time.
What's different here is that as the office workers, they had to clock in their hours into a certain program. That tracks what they did. So in other words, if they're saying they did X, Y, and Z work and they're really at home, I mean, do you get more blatant than that? I mean, that seems to be concrete evidence, although, again, I don't think it's an open and shut case for Mr. Bradsher just yet. Just because you have one person who already pled guilty and now is testifying against Bradsher, that's not entirely a closed and shut case for him, is it?
No, because he could say, look, he's trying to create this testimony to save himself. He's cooperating with the governments in order to testify against me and get a better sentence for himself because he hasn't been sentenced yet. And the defendant can say, look, what he's saying just isn't true. That's not how we arranged this. And unless there are emails or recordings in some way to show that there was this arrangement, it might be hard to prove. So the defense can argue that. But if they did what they were accused of, it's amazing that they did it so blatantly and openly that other people could see that these wives were not showing up for work, because certain jobs you could work from home and you can say someone's telecommuting, but law enforcement, DA, that's not the kind of office setting where people could work from home. You need to be involved with the cases, in either helping out attorneys, helping out other people. So that's
I'm not even here right now. This is a hologram. I'm at home right now. We have a very
advanced... You look so 3D, though.
Thank
it's amazing.
You. We do really big things here on Law and Crime. Speaking of big things, we are going to be taking a break. And we're going to, in this break, we're going to be talking about a new book that's coming out that we're very happy to announce from our very own Lee Wheel. So let's play you some of that. We are going on a short break, and when we come back, we have a lot more to talk about in the Wallace Bradsher case.
We have a very special segment for you here on Law and Crime Network. Right now, we are going to take you inside the mind of Charles Manson, one of America's most infamous serial killers. And to help me do that, I have a very special guest and also a host here on the network, Lee Wheel, who is the author of a new book that's coming out, Hunting Charles Manson. First off, Lise, tell me, why did you want to write this book?
Well, you said it exactly right, Rachel, that he's one of the most infamous murderers, but he's more than that. He's really a cult figure from back in 1969. And I really wanted to write an historical thriller and tell really talk about that era, that time, because I think it's so relevant to understand that time and that sort of cult phenomena, to understand what's going on today, and really to make sure that it never happens again.
You know, and I was reading your book last night. It's so scary to think this guy was able to manipulate these women.
That's right.
It's really unbelievable. But let's talk a little bit about this, because particularly I think there's been renewed attention towards Charles Manson because he just died a few months ago.
Right.
Walk us through a bit what your book tells the readers.
Well, it does start really with how he was able to kind of get these young women, many of them were teenagers from good homes. How was he able to sort of brainwash them and get them to actually go and commit these heinous crimes? So I wanted to follow that through, and I did that in the search for Charles Manson. In doing that, I also followed through the investigation. And Rachel,
but you're saying, I mean, they really bungled this investigation on two fronts.
They really did.
And what's kind of crazy about this case, here is this guy that was able to lure these women and get them under his spell. But he was kind of a loser. I mean, he had just been released from prison at the time. And parole officers were supposed to be keeping track of where he was. They kind of dropped the ball.
Yes, and released again and again and again from different jurisdictions, mind you, right? If the parole officers had been on their job faster and sooner, he would never have been released, or he certainly would have been checking in much more often.
But you're also saying there were some issues between the correspondence between the Sheriff's Department and LAPD. If they had shared information between the two agencies, perhaps some of these murders could have been prevented.
In the murders themselves, and in the previous murder, Gary Hinman murder, which had happened a few days earlier, which was in the area, but not quite as close as in the downtown Los Angeles area. That had happened. It had all the markings. There was, you know, blood on the walls, that kind of thing. I don't want to go into too many details, gory details, but they had literally some of the same markings. But because there was this kind of, you know, fiefdom among the different jurisdictions, they didn't want to share information, and they bungled it in that way. And they did some pretty, you know, silly things too, like walking on some things and tampering with evidence.
A lot of times when these law enforcement agencies get territorial over the cases, they don't want to share information. They're not thinking about the greater good here, which is stopping this guy.
And the problem, Rachel, is, again, one of the reasons I wanted to write this case, wanted to follow this case now, is that happens, that territorialism happens today as well, and we have to guard against that, because this crime could have been solved a lot faster had that not happened.
Absolutely. One last question for you before we wrap up. Let's talk specifically about Charles Manson, because he was not the one that actually plunged the knife into these victims. So that creates a whole other level. If you're the prosecutor then trying to prosecute the case, how do you convince the jurors this guy is guilty of murder if he isn't the one that actually did it? And your book takes us through that.
Yes, so this was critical at this point. Vincent Bugliosi was the prosecutor in the case, the main prosecutor. There's some juggling going on there as well, which I go into the book as well. But Bugliosi had really, you know, new territory here, convincing jurors about conspiracy theory. Even though you're not the one with the knife, once you set those things in motion, once you tell Tex and, quote unquote, the girls who you've trained and you've told them what to do, once you set that plot in motion, then you are legally as liable as if you had plunged the knife yourself.
I really do encourage everyone to read this book, especially those that are true crime aficionados. It's really a step-by-step of what happened in this case, and we appreciate Lise being here to discuss some of it. Thanks so much.
Okay, everybody, so we're learning about how 2 district attorneys entered into this alleged scam to defraud the people of North Carolina by hiring each other's wives for no-show jobs, basically getting paid for work that they didn't really do. And who pays them? Taxpayer money. So let's talk a little bit more about this with Law and Crime trial analyst Dan Schorr. Dan, Cindy Blitzer, who we're kind of hearing a little bit more about, that is the wife of Craig Blitzer, the witness there. She was hired into Wallace Bradsher's office, the defendant. Will she testify? I know she's not being charged in connection with these crimes because I think that was part of the arrangement that Craig Blitzer worked out with the state here. But do you think she's going to testify against Wallace?
I would expect so. I would expect her to, because I don't know why she wouldn't. She's the one who had the conversations with Bradsher and can say, what was the understanding? Did he know that I was showing up to work? Do you know that when I wasn't showing up to work? She could talk about the relationship and what she did do, what she didn't do. Without her testimony, I think the case in the prosecution is kind of incomplete, and there's no reason why she wouldn't testify. She's not being charged. So she's not facing legal jeopardy anymore, it seems. So I would expect her to testify. And that's going to be fascinating when she's cross-examined by Bradsher. Just like we were talking about how he's cross-examining the other district attorney, he'd be cross-examining his own former employee and the wife of the other district attorney.
And he's a good district attorney. In his opening statement, he talked about how successful his office was at prosecuting different crimes. And you can even tell, based upon the way that he speaks in the courtroom, he's a very good attorney. She might fold under that questioning. I mean, what's the worst thing that could happen if she takes the stand and he grills her? What's the worst thing she could possibly say?
For the prosecution?
Yeah.
For the prosecution, if she recanted, if she said, look, he thought I was working and I deceived him and he really had no idea that I wasn't showing up, that he didn't come to the office, the part that I was in, and he didn't realize that the scam was going on, that would be hurtful to the prosecution. But there's no indication yet that she's going to say that. She's going to be called, I suspect, as a prosecution witness, and therefore you think she'd be helpful. Also, remember, her husband has yet to be sentenced, so she wants to help the prosecution if she can.
So Craig Blitzer, this witness that we keep playing, and also we expect the live feed today, and he will continue to be grilled under cross-examination by his co-conspirator, the defendant, Wallace Bradsher. He won't get sentenced until this case is resolved. So how would that work exactly?
It's common that if someone pleads guilty and part of their plea is they have to testify against the person they did the crime with, that they're not sentenced until after the testimony. And one of the conditions is you have to be truthful in your testimony in order to get a favorable sentence. Now, what is truthful? That's up for interpretation. And the defense can certainly make hay out of that, saying, oh, you have a reason to lie, you have a reason to help the prosecution.
But if Bradsher's found not guilty, could Blitzer still be, I mean, he already pled guilty. What would happen to him?
Presumably, if he gave what the prosecution deems to be truthful testimony, they're going to give him a favorable sentence, or at least what was talked about before the case. Because remember, the prosecution's credibility is on the line. They're telling witnesses on other cases, if you cooperate with us and testify truthfully, you'll get a more favorable sentence. So if they went back on that deal, that would undermine the prosecution's credibility on everything. So they have no reason to do that.
So Craig Blitzer hired Wallace Bradsher's wife, Pam Bradsher, and Wallace Bradsher hired Craig Blitzer's wife, Cindy Blitzer. Let's learn a little bit more about the work that Pam Bradsher was doing in Craig Blitzer's office. Welcome back to Law and Crime, everybody. I'm Jesse Weber, and we are replaying some key testimony for you in the Wallace Bradsher case out of North Carolina, a district attorney who's in some pretty hot water for allegedly entering into a scheme with that man that you just saw, that other witness who was testifying, Craig Blitzer. There were two elected officials, two DAs, and the scheme is that they would hire each other's wives for no-show jobs. They would basically be paid for not doing any work. And this gets worse because this is not just any office. These are two elected officials who are supposed to uphold the law. And Craig Blitzer, as we talked about, has already pled guilty, and now he's testifying against his co-conspirator. I'm having trouble with that word today. Wallace Bradsher, the defendant, is defending himself. He's not represented by counsel. He is actually doing this whole case by himself, and he has the ability to cross-examine Craig Blitzer on the stand. We saw a little bit of it yesterday, where it's going to continue on today. It should be noted that there is an update. There is a delay in the case, and I'll explain to you why. It's a little complicated, but just to break it down, there has been new evidence that has been discovered that is being sent to the prosecution and will also be sent to the defense. And it is about an email from a key character in this case named Mark Keeney, who sent the prosecution last night an email that he had text messages between him and Blitzer, who, again, we were just watching, that somehow alleges that Blitzer said that Bradsher told him that he needed to fire him. So if you have new evidence that Bradsher is trying to influence the office of Craig Blitzer to try to fire him, it will be very interesting to see how it plays into this overall case.17 I'm here with Dan Schorr. We don't know much about this evidence yet. We're learning a little bit more about it. It has something to do with Bradsher wanted Blitzer to fire this guy, Mark Keeney, over conversations that he had with a political adversary. Even if that's all true, how does that really tie into this case? Does it show just more evidence of manipulation and corruption?
Maybe. We don't know yet, but it could show that. It could show just a prior bad act that could undermine the credibility of any witness. You could cross-examine them on something that they've done in the past. And the prosecution, if they know something against their own witness, they need to turn that over to the defense. So if they're notified about it in the middle, they have to notify the court, and the defense hands it over. So that might be what's happening now. You know, listening to that testimony, it's really interesting because the Blitzer saying how they got guidance saying you can't hire your wife. But why would you even need legal guidance there? It's so obvious that there's an appearance of impropriety when someone is supervising their own spouse, because if that person doesn't do their job function right, are you going to fire your own spouse? Are you going to discipline your own spouse? And appearance of impropriety can be just as bad as real impropriety when you're dealing with the credibility of a law enforcement organization. So it should have just been common sense from the beginning that this was something that should not have been done.
That's why we have nepotism statutes in the first place. That's why hiring family and friends is so dangerous. I mean, why? You made a great point earlier in the program when you said if they wanted them employed, why not employ them in a... They have a lot of connections, okay? They're the district attorney. I'm sure that they could find work for them in some other department that wouldn't conflict with theirs. But having them work in each other's office so they could directly supervise and see what's going on, I mean, how do you escape that fact? Also,
first they wanted to hire their own wives, and they did, and then they said, we're going to switch wives, but that's violating the spirit of what they just learned. They just learned you can't supervise your own wife, so they say, okay, we're going to supervise each other's wives, and you really have the same issue there. Are you then going to fire the wife of the other district attorney who's hiring your wife? It's the same concept. So obviously, if they were told hiring your own wife is inappropriate, they should have known swapping wives and hiring each other would also be inappropriate. But again, as I said before, if they just showed up and did their jobs, you might have seen an ethics complaint, you might have seen some other consequences. You would never see a criminal trial here like you are here.
And Bradsher faces up to 18 years in prison. Just from a different perspective, any attorney representing himself in a case is dangerous, but can you explain to our viewers why that's so?
Sure. This is a saying, anyone who represents himself has a fool for a client. And that's because when you have to make a logical, coherent argument, if you are the defendant, you are emotionally involved. And you may have your own emotions swaying you to say something, to not say something. And you really want a detached lawyer who's smart, who's thinking about everything, and can really make the argument for you. That's why when you see big-time lawyers, successful lawyers get in trouble, which happens, they hire other lawyers to represent them.
Michael Cohen?
Right. You always see them, or almost always hire other lawyers to represent them, because even though you know the law, you are not detached enough to make all the legal motions you need to make, to argue in court the way you need to argue. You really want a separate person as your advocate, and he chose not to go that way here.
I tell you, I watch Bradsher in court cross-examining these witnesses, including his co-defendant. If I was there, I'd just be thinking in the back of my mind, prison time, prison time, prison time, prison time. Ask the right question, because you know, you watch a lot of these cases, and the attorneys are representing their clients zealously, but at the end of the day, they're not the ones who are going to jail if they don't get their client off. You know, that's the thing. Here, there's such a personal stake, and that's what makes this case extremely unique, but fascinating to watch nonetheless. Again, since the court is delayed with this introduction of new evidence, we are going to continue playing you some more testimony from Craig Blitzer, this key witness. This is when he starts getting into the fact that the work for their wives started to slow down. Take a look. Welcome back to Law and Crime, everybody. That is Craig Blitzer talking about how he hired another district attorney's wife, the Wallace Bradsher, the defendant in this case, hired his wife, Pam, and how Wallace Bradsher, the defendant, hired Craig Blitzer's wife, Cindy, and how they were really operating, getting paid, but really not doing a whole lot of work. So it's kind of like, actually it's very much like, stealing taxpayer money, having two wives work and get paid. And Cindy Blitzer, who was working for Wallace Bradsher, the defendant, got paid $48,000. She had to return that money for work she didn't do. She was really in nursing school. Well, let me rephrase. That is really the allegations put forward in this case, and we are covering it live here on Law and Crime. We are waiting for that feed. I'm keeping a very careful eye on it. As soon as we have a feed in that courtroom, we'll make sure to go to it. But I want to bring back in Law and Crime trial analyst Dan Schorr. We talked about in the break how this is a unique case and that the defendant is representing himself, and he doesn't need to testify in his own defense because he's getting a lot of information from these witnesses. But what would it look like if he went on the stand? How does that work? Because he's representing himself.
Right. There's two parts to that. First of all, he doesn't have to testify because he's getting his story out through the cross-examination. He's saying, didn't this happen? Didn't that happen? And then he doesn't have to testify. And the reason defendants don't testify is they don't want to be cross-examined by the prosecution. So he might not have to for that reason. Now, you asked how would it look?
Yeah, how does it practically work when a defendant is representing himself? How would he cross-examine himself?
And there's that great courtroom.
Or direct examination.
There's that great courtroom scene in Bananas, the Woody Allen movie, where he's cross-examining himself, and it's very adversarial, and he's jumping back and forth. Here, he would probably just make a statement because he doesn't have to, he's not going to ask a question and answer it. He'll be able to make a statement on direct. But then when he's cross-examined by the prosecution, he'll be in the unusual situation where he can object as a witness to questions being asked by the prosecution. So he'll be both the lawyer protecting the witness and the witness. So it's definitely unusual.
So in other words, if he's sitting here and the prosecuting attorney asks him a question, he'll be like, objection, Your Honor, and then we've never seen that before.
Right. Well, sometimes you see pro se defendants represent themselves. Usually it's because their case is very weak and they have some kind of problem that makes them think they should represent themselves. Here it's unusual because you have a skilled, experienced attorney representing himself. Usually those people know better not to do that. So he would know what objections to make, and I'm sure he's going to be active. It's going to be interesting to watch.
You talk about the movie, I think you said Bananas.
Yeah.
I mean, how great would it be? It was, Mr. Bradsher, did you hire Cindy Blitzer? Yes, I did. And they're going back and forth and asking himself questions. I don't think it's going to work like that, but we'll have to see.
We'll see.
But as you said, I think he would probably make a statement, and maybe he won't take the stand because he's getting so much information out of the key witness here, Craig Blitzer. I can't stress that enough. This is probably the most important witness in this case, and you have the defense attorney who's representing himself grilling his co-conspirator on the stand. We haven't seen this before. At least I haven't seen this before on Law and Crime. We are going to take a quick break. When we come back, there's so much more to discuss in this bizarre case out of North Carolina. We'll be back in a minute. Welcome back to Law and Crime, everybody. I can't get enough of this case. I really can't. You have a district attorney who's on trial for conspiring with the witness you just saw, another district attorney, to hire each other's wives, pay them, and they really didn't do any work. And that's basically stealing taxpayer money. But what I really can't get over is the fact that the defendant is representing himself and has the opportunity to cross-examine his co-conspirator. Dan, I'm here with Dan Schorr. I can't get enough of watching this. I could watch this all day, watching an attorney grilling another attorney and grilling his co-conspirator in the courtroom. It's not like he's represented by counsel. He's asking the questions himself. How awkward is that, the two of them talking to each other in court?
They are talking to each other. It sounds like a conversation where he says, well, isn't it true that this person was the supervisor? And he says, well, if you say so, well, don't you remember we talked about this? Well, I think you have your date wrong. And it's as if they're trying to figure it out amongst themselves. And as I said before, the defendant is kind of testifying through his cross-examination because he's getting his version of events out. It's a very unusual situation.
If they weren't in a courtroom and they had the opportunity to speak to each other, and Wallace Bradsher could look at Craig Blitzer and say, Craig Blitzer, he took a plea deal to testify against Wallace Bradsher. What would the exchange be like if the two of them were put in an empty room together?
It probably wouldn't be as polite as you're seeing in court and respectful. So. There's certainly a lot of history between these two. They allegedly conspired to commit this fraud, and then one pled guilty. They were district attorneys, and now they're adversaries in a way. One's a witness against the other.
I'm noticing a lot of times Craig Blitzer saying, I don't remember that. I don't recall. Doesn't seem to be consistent. How is a jury supposed to believe two people here? How are they supposed to believe either the defendant or a witness who's already pled guilty to the crime? How do they separate who's telling the truth? Because I find it impossible.
It's difficult. You have to see what corroboration there is. They were talking there about who Blitzer's wife's supervisor was when she first started working there. I'm sorry, Bradshaw's wife's supervisor was. You're right, Bradsher, when he started working for Blitzer. So I'm sure there's some documentation that can attest to who the supervisor was. So like in any case, when there's two different versions of events, who's corroborated by other witnesses, by testimony, by documentary evidence, and then also you think about at the end, when they argue in front of the jury, it's up to the prosecution and the defense attorney, in this case the defendant, to really put together why certain inferences should be made from the evidence to reach one conclusion or another.
But the one thing that I'm also getting the sense of is that Blitzer was told by his attorney, hey, it's okay, you're not in trouble. If Cindy works, if Cindy clocks in and gets paid but really doesn't do work, it's okay. I'm confused by that whole line of questioning. Is Bradsher getting out, and I think this is a good point, you're telling me your attorney told you this, and okay, so your attorney told you this, but I never told you it was okay. What am I supposed to get from that line of testimony?
I guess, it's a double-edged sword, because on one hand, if he shows that Blitzer did things that were unethical, it might undermine his credibility. But in this case, because Blitzer is accused of doing the conduct with Bradsher, then it really undermines, you could undermine Blitzer's credibility, but then what does it say about the fact that you were working with him in order to come up with this scheme, allegedly?
Yeah.
So I'm not sure how much mileage you get out of that, but certainly he's trying to show that Blitzer himself wasn't using the best judgment. But what does that say about Bradsher?
And who to blame? Who to blame for ultimately doing this? Again, it's alleged that they concocted this scheme at a pizza restaurant one night after they realized the ethics rules came down and said they couldn't employ their own wives, so that they came forward and did a wife swap where they'd hire each other's wives. I haven't heard anything like this before, and thankfully, I've never heard anything like this before. Let's play you some more of the testimony as we wait for the live feed. I actually see the courtroom seal, so there is a camera feed in there, but the court hasn't started yet in this case. But let's see Wallace Bradsher, the defendant, cross-examining his co-conspirator, Craig Blitzer, a little bit more. Again, I said I could watch this all day, so let's watch a little bit of it. Welcome back. We are recapping some of the Wallace Bradsher case out of North Carolina. We are waiting for the live feed to begin in that courtroom. We expect that this witness, Craig Blitzer, will continue his testimony and will continue to be cross-examined by the defendant, Wallace Bradsher, who's representing himself. Let's bring back in Law and Crime trial analyst Dan Schorr. Craig Blitzer is basically saying to Bradsher on the stand, you told us to lie. That's a very heavy accusation.
Right, and Blitzer's drawing a distinction between him and Bradsher, saying, I might have done these improper things, maybe illegal things, but when the investigation time came, I cooperated and I wouldn't lie to investigators, and that's different from what you did.
So Bradsher's facing a lot of different counts, okay? He's facing a lot of different issues here, and again, he could face up to 18 years in prison. In your opinion, what is the prosecution really nailing home right now, and it's sticking with the jury, and what are they maybe they're not elaborating more, and maybe they need to do a little bit heavier?
Well, it seems the strength of their case through Blitzer's testimony is that there was this plan together, that they did want to defraud the taxpayers, that they arranged to have their wives swap jobs even though it seems improper, and that they weren't on top of them showing up to work and were supporting them not showing up to work. So that shows that there was this plan to defraud. Now, what they have to strengthen more, I think, is what Bradsher knew in terms of Cindy Blitzer, what she was doing, where she was working. What did Bradsher know about Cindy's work to show that he really knew she wasn't really doing her job? And I think her testimony is going to help with that later in the trial.
Pam Bradsher, who is Wallace Bradsher's wife and was hired by Craig Blitzer, they ruled that she did do her work, that she was paid for properly. But here we're talking about Cindy Blitzer working in Wallace Bradsher's office, and she didn't have work to do, and it's being accused that he said there's a family comes first policy, that she can do her nursing school studies, she can go to nursing school, and I'm still going to pay her. Is that the understanding of what the prosecution's saying here? And
they also said something about taking care of your children. It's
right.
Interesting they put that out there, because a lot of offices say correctly it's family first. If you have a family priority, such as your children need you for some reason, that you can do that. This is a different kind of family first, where family first seemed to mean you don't have to go to work at all, that you don't have to do your job at all, or very little. So that seems to be taking it to an extreme that is not normally the way what normally people mean when they say it's a family first office.
And we talk about Craig Blitzer testifying against Wallace Bradsher. He took a plea deal. He has yet to be sentenced, but his wife returned the $48,000 that she earned. And what sentence could he really receive? Could he receive jail time?
Based on the charges he pled guilty to, he could, but you would think that if he agreed to testify and cooperate and plead guilty, there's some kind of more lenient plea and sentence for him. Sometimes defendants, when they agree to these plea bargains and they agree to testify, they know what the sentence is going to be. Sometimes they just know a range of what it could be. And sometimes they don't know at all, but they just have to rely on the prosecution feeling that they cooperated with the prosecution in the case. So we don't know what he knew and what he ultimately will be sentenced to.
His law license was suspended. That's a big deal. That's a huge deal. It was very hard becoming an attorney. I'll tell you that, for everybody knows. It's very hard, a lot of work getting put into that. So you having your law license suspended is not good.
Right, but based on these facts and what he pled guilty to, there's no way he's getting away without his law license being suspended. He was the district attorney admitting to fraudulent conduct, so that's the least of his problems, right?
Yeah, exactly. And it makes you wonder, if he wanted to fight this, he would have fought it, but he took a plea deal for a reason, right?
Well, there's a lot of exposure. He's facing significant prison time and the cost of the defense, and also that it's corroborated a little bit by what he just said before, that when the investigation came, he decided, according to Blitzer, that he was going to be truthful, that he wasn't going to be deceptive, and maybe part of that is pleading guilty and cooperating with the prosecution.
Dan Schorr, thank you so much for joining us. It was great having your perspective on this really bizarre case. Again, Dan is the managing director at Kroll, the investigation firm, and our very own law and crime trial analyst. Thank you so much for joining us.
Jesse, it's always great to talk with you, and it's a fascinating case. I'll be watching.
Sounds good. Well, can't wait to have you back. All right, ladies and gentlemen, as we wait for the live feed back in this courtroom, let's play you a little bit more as these two district attorneys face off, literally face off against each other in court. We'll play that for you right now.